Hi guys, it's Kathy. I hope you're doing well. I hope you're staying warm. It is funny to me when people say that it's like 20 degrees out and it's cold. No, that's not cold. Um, I watched Judge Fleischer's court and I see, like, you can tell when it's a tiny bit cold in Texas because when the people come into the courtroom, the coat stays on. Like, they just keep the coat on. The coat, they probably go to bed with that coat on. People in Texas, they'll take their coat off when it's above 50 degrees, sir. Nine, 9 degrees, Kelly, that's cute. You have to have a negative in front of whatever you're about to type to me. I lost my dog. I didn't, okay, obviously you hear my dog. So I found my dog, but that was before. Let my dog outside, and it was in the middle of the day, and the wind was unbelievable. So it was frigid cold here, frigid. And I'm in this sort of like I'm in this sort of dip where the the cold comes right from Canada down and hits me. All right, and above Canada is very, very cold. It's just all cold. So it comes and it hits. And then sometimes, the pressure or whatever brings that a little above me. But on that day, I lost my dog. It was frigid and it was so windy. And, I grabbed my coat and I put on, just a quick pair of sandals. No socks or anything. I'm out walking, looking for my dog. Nobody around me would think that that is crazy. They just wouldn't because it's in Pennsylvania. We're used to the cold. The cold is fine. But I just imagine people in Texas going outside like barefoot today. I would go outside barefoot I wouldn't stay out there for 7 hours, but I wouldn't do that anyway. But I committed a felony before I got online today, guys. I cut them off of something. I'm not going to tell you what I cut them off of. That way, the FBI will have a harder time prosecuting me if they're watching. And they're always watching. But is that a felony? Or is that just a misdemeanor? I know it's federal. I know it's a federal crime, but is it a felony or is it a misdemeanor? It doesn't say. All right, I got a special. We're going to do a special field trip today. We're going to go to Dr. Dennis Business, and I put his link in the description of the video. It's still Michael, but Michael did an interview, and Dr. Dennis Business has a whole bunch of stuff on his YouTube site about Michael. This is just one quick field trip we're going to do, and we're going to see Michael talk. This was 2 years ago. I should qualify that. Dr. Dennis put this video out, this interview out 2 years ago. So I actually don't know when the actual interview took place. In my head, it was 2 years ago, and he's still acting like this today. But I don't know. I don't know. There's other videos on his site about Michael McDonald. Oh, I didn't share my screen. You're going to have a hard time watching this with me. It's my first day. There we go.
Chapter 1: Lawyers and the Daycare Incident.
But yeah, I was so distraught. I was so distraught not being able to see my kids for 90 days, And I found out that George McGlaris, his father, was an attorney out here, had shot himself in the past too, and had also committed suicide. And he was such a good lawyer, rest his soul. He was a good attorney. He helped me get every weekend with my kids.
So your third lawyer was good?
No, my second lawyer, the one that shot himself, was a really good lawyer. He got me every weekend. We were about to get joint custody. Everything was, but once that happened, everything went downhill from there,
So the second your lawyer committed suicide before your court case, everything started going downhill?
Yeah, I just paid him $5,000 to finish trial. And then, yeah, it was so crazy. I had to go try to get another attorney, and my ex had cleaned me out. So I had to go try to get a payment program and get some other attorney. I called maybe 50 different, it's like, hey, I have a pregnant female judge, and she's been really biased. Doesn't let me see my kids. And it's like, is it Department B? Yeah, that's my wife. I was like, oh, okay, I can't represent you. I was like, do you have any referrals or anybody else I could go to? He says no. And I guess this guy's name is Harry Marquis, and I guess he's her husband, which is like 20, 30 years older than him. And anyway, yeah, so I ended up going and retaining a guy named Kurt Smith, and he said, oh, I'm really good in front of Marquis. I'll get you your joint custody.
Yeah, I hope you're doing well.
Yeah, that's my third lawyer.
So he said he was friends with the judge and he'd get you custody.
Yeah, he'd give me. So I gave.
And what was his name?
Kurt Smith.
Kurt Smith in Nevada, in Las Vegas, Nevada.
Kurt Smith, yeah. So he said he'll show up, and then during that time, I'm really distraught. The hearing is like months away, and I ended up going to the church. I go to I don't know if I was restricted from going to the church or no. I just had a restraining order that said I couldn't go near her. So I saw the vehicle there, and I'm like, oh crap, okay, I'm gonna make sure I don't run into her. But I knew my kids were over there at daycare, so I was like, man, I really miss my kids. It's been over 60 days. So I went over there to daycare and said, hey, can I see my son and my daughter? And like, yeah, go ahead. And I go say, hey, Mason, Daddy didn't abandon you. I love you. And I'm hugging him. And then the campus security comes over there at Canyon Ridge, and they're like, oh, you need to leave. I was like, well, can I see my daughter? I haven't seen him for almost 2 months. Like, I really miss him. And then I end up going down to I end up just leaving without incident. And I guess she filed a police report off of that. And I get a card in the mail that says you have a bench warrant for your arrest. And I'm like, oh my gosh, what the hell? Like, I didn't break the TPO.
Michael broke the restraining order by attending the church Candace was at.
I just went to the church, but maybe because she was there. So I was supposed to go out of the country for this training for Geotab. And
what's Geotab?
Geotab's the third largest tracking device company that I work for.
So this is your company.
This is where Michael got the GPS trackers to put on Candace's vehicle in order to track her and the kids.
And this is the first restraining order that your wife got?
Yeah, I think it was the first or second, yeah. So,
okay.
So I go I'm supposed to leave the country, go to Canada, and I have this bench warrant, so I'm not sure if I'm going to get arrested if I leave the country.
Bench warrant. Noun. A warrant issued by a presiding judge or by a court against a person guilty of contempt or indicted for a crime.
And I ended up going and filing a motion to dismiss this bench warrant so I can get it off my record. I asked an attorney if they could do it. They said, oh, we're going to charge you $1,000, you can do it yourself. So I go up to the court to file it, and they say, oh, here, they took my license. They said, you got to go see the judge. I go upstairs to see the judge, and they arrest me in court.
Hold on, you got to go back. This is crazy. So you were on your third lawyer?
Yeah, I was on my third lawyer.
You're on your third lawyer, and your third lawyer didn't file the paperwork. You did?
Yeah, I filed because it was a criminal matter. So he only did family court or whatever. So they were trying to charge me with a criminal bench warrant. So he didn't handle the criminal side. He only did family law.
But what would the criminal bench warrant be for?
For the TPO violation. Which is
TPO is a restraining order.
Temporary restraining order.
And what did she say you do to violate the restraining order?
She said that I went to the church and tried to abduct the children at church. I never tried to. I just wanted to see my kids and say hi to them,
We all know what happened at the daycare when Michael picked up the wrong child. He had a restraining order to stay away from the kids and Candace.
And that's all I did. And I got to hug my son and say I love him and I didn't abandon him and I'll see him soon. And they wouldn't let me see my daughter, so I ended up just leaving. They asked me to leave, I left. But I still got a bench warrant in the mail. And then I tried to get this bench warrant quashed before I go to Canada, and I get thrown in jail. And they throw me in jail. They denied me bail.
Chapter 2: Jail and Hearings.
they put me in this freaking, it took forever to do intake. They put me in a concrete room with 30, 40 other people. You have to sleep on the ground, and it's just terrible. The most horrid food you can imagine, and you're just stuck like sardines. You have to sleep on the floor for almost 3 days, no bed. You have to sleep on the concrete floor, the cold.
In Las Vegas.
Yeah, and that's the drunk tank or intake, and they purposely keep you
In the
there for
cold
3 days
in
to
Las
see if they'll bail
Vegas.
out.
Michael was not bailing out of anything. He was staying in jail, and deservedly so.
And it's just torturous. I mean, you can't get sleep. You're so deprived. And then I had to go to court when I'm super, sleep deprived. And I'm on the video camera asking the judge, please let me go. I got a training denied bail, denied an OR. It's own recognizance release. And then I ended up getting out, and I signed that stupid plea deal.
Michael would have signed the plea deal because going to trial would have been much worse.
So, and then I finally get a second evidentiary hearing, right? And I end up having, Kurt Smith didn't show up either. My other attorney, he said that he's really good. He sent some guy named Mark Anderson, that's this huge dude, his bar number is 666, and he freaking comes in there and says, oh, I was like, where's Kurt Smith at? Oh, I'm representing you. I was like, I've never even talked to you about my case. Oh, I've studied your case files. Well, the day I show up with Mark Anderson, I go in there, and I told him, listen, I called a bunch of attorneys before you guys, and I tried to contact, I actually contacted the judge, and the judge brings this up in open court, says, oh, he tried to contact my husband, and that my mom is outside of the court calling me saying, your judge uncle, Judge Bonaventure, he did the Binions trial. He called my mom and said, what's up with Michael? They just called me or something, Metro or something, the Department of Homeland Security, like they think I'm trying to hurt the judge or something. I don't know. But anyway, I'm like, I didn't do anything.
Michael is skipping a lot of facts while sounding like a guilty person.
So I go to court, and the judge brings this up in open court, says that he tried to call my husband, and then I had a guy from the Department of Homeland Security come up to me in court with his badge and flash it. Do you want to harm the judge? I was like, what? I've never made any threat or did anything, No.
Chapter 3, Domestic Violence and Judge Linda Markey.
Oh yeah, he pushed her one time, or he put her in handcuffs, and there was one time where she was punching me, and I said, he punched me again, I'm gonna put you in these toy handcuffs, and I did, and we used to,
Imagine just for a second. Imagine 6'4", 250-pound Michael McDonald putting Candace in a pair of toy handcuffs against her will.
Why would
we
she
used to have
punch
sexual
you?
things or whatever, it was just, it's crazy.
Why would she punch you?
Don't bother asking, why did you put her in handcuffs? Or how long was she in handcuffs?
What?
Why would she punch you?
She had, like I said, she would get very, like the flight response was really big. I would try to go and hug her and calm her down, and she'd be wailing on me, you know what I mean? And yeah, I've never called the cops on her or anything like that, you know what I mean? But
Well, why didn't you have a mental evaluation on her to prove she's insane?
we asked her for one, and the judge said no. And then
What is her name?
They made who, my ex or
Yes.
the judge? Candace. Yeah.
Candace, okay.
But they ended up. Her attorney said, "Oh, we want him to have a mental eval." I'm like, "What?" So I ended up getting a mental eval, and I was.
You got the mental evaluation, and she didn't get the mental evaluation?
Yeah, they didn't require her to get one. So I had to go find a psych when I have adjustment disorder. I'm going from being a father and a husband to just being a single bachelor again, like
to being attacked by family law court
completely rarely
in Las Vegas, Nevada.
Yeah.
The interviewer has done zero research and giggles about things like domestic violence, gun violence, and domestic abuse.
So anyway, the judge ordered that I refinance the house or sell it. We had over 140 in equity, and I had a refi approved. I ended up going back to court again after the trial. I go back to court again. Let's see what happened there.
Well, the chat wants to know about why the judge would think that you were threatening the judge.
Michael was trying to create a conflict of interest any way he could. Judge Markey has a husband that is also a lawyer, and Michael tried to retain his counsel, so Judge Markey would have to recuse herself.
Let's talk about that story.
Because I called her husband. So
you called the
I didn't
judge's
make any
husband?
threats to her husband. I was an
Did you know it was the judge's
At
husband?
the time, I did not know it was her husband. No.
So when you called the judge's husband, you didn't know it was her husband, and he's a family law lawyer.
Yeah.
And you were interviewing him to maybe take your case, and you didn't know that his wife was the judge in your case.
Didn't know. I called about 50 different lawyers. So
And then the judge started feeling like you were intimidating her,
something like that, yeah.
and that's ridiculous.
And I think I made a statement too, saying that, oh, I hope your pregnancy goes well or something. My uncle had disclosed some information which he probably shouldn't have, that she was having a difficult pregnancy, that he would have to fill in for her or something, but he couldn't do it because we're family, you know what I mean? So he had to recuse himself from that position.
So I didn't know this guy was her husband. I had no idea this guy was her husband. But then when I was talking to him, I said, I hope you have an okay pregnancy.
So I made that off comment I shouldn't have, and anyway, yeah, I blew up from there. So ever since then, the judge would file all these things and allegations, and
So somehow the judge got pissed off.
yeah.
The judge got pissed off.
And she also knew me from my being a witness in my parents' case too, which should have been a conflict and been recused as well,
And the judge was the same judge that got your mother and stepfather divorced.
Yes, correct.
Okay.
Yep.
So then they required you to get a mental evaluation, but
Right.
not the wife to get a mental evaluation.
Chapter 4, Rectal Prolapse and the Fight at the In-Laws House.
I see her car there, and I see the freaking new boyfriend over there standing on the corner,
That would have been Big Daddy Joe.
and he sees me, and and during this time there was some allegations of some stuff like my ex had texted me during the time when I went to see my daughter for the 90 days that my daughter's having rectal prolapses where she might have to have surgery. I'm like, what the hell's happening?
What is that?
Rectal prolapse occurs when the lining of a child's rectum protrudes through the anus and outside the body. This can occur because the ligaments and muscles become weakened from problems including chronic constipation, chronic diarrhea, or straining while going to the bathroom.
I was very concerned about that. And she said, she texts me and says, oh, she's having rectal prolapses and she might have to have surgery. I'm like, why is she having that? Oh, she's straining. It's a food allergy probably. And I'm like, okay, who's watching our daughter? That's the first thing I think of. And then I ended up going and saying like
Michael was saying that someone was raping his infant daughter. He had only one target and only one motive.
who's watching her? And then she tells me that she's got a new boyfriend and he's been watching the kids alone. And I looked this guy felonies for sexual assault and lewdness of a minor.
What are you talking about?
Yeah.
So your wife starts dating a man who has
So
criminal charges of sexual assault of minors?
This guy was like a couple years older than her, like 5 years old. I guess he used to go to a college group and try to pick up younger chicks. And a lot of girls were like, we knew about this guy before. Her friend had just divorced him. Like one of her best friends divorced him. That she said he had raped her in the past or something too. So he's known to have raped somebody. He used to be, comic book store guy. A lot of girls were telling me that they made him feel really awkward. So I'm like, oh great, my daughter's being watched alone, and I have talking parents messages saying that he's watching her alone, and that
This is all nonsense. It's all to assassinate someone's character. Michael can't handle that Joe is better. It eats at him.
like, let me have the right of first refusal. If refusal.
Okay, what's the right of first refusal?
That's where if you have something going on, you have to get a babysitter, that you have the other parent give them the option to watch them before.
So right of divorce decree.
Yeah. So that way, in case instead of getting a babysitter, you give the other party an option to see the children or watch the children before you go let some stranger watch them. So I asked for that, and my attorney, like I said, my attorney ended up dropping from the case, so I had to file a lot of stuff afterwards. But anyway, so during this time, I'm really concerned about my daughter, and I found out this, there's 9 felonies for lewdness of minor, sexual assault. I sent this to her through talking parents. What the hell, Candace? You're letting this guy watch our kids? Oh, that's not him. He doesn't have a middle name. I'm like, what are you talking about? He's about the same age. He's got, I'm stressing out. You know what I mean? Like, so I didn't see my kids for those 90 days, and then she starts having rectal prolapses, and so anyway, I finally get my kids after the divorce decree gets put in. I see them every other weekend, and my son and daughter, they tell me, like, I was like, how's everything been going? It's like, oh, mommy has a new boyfriend, and he's been watching us or something. And I'm like, okay, you guys doing okay? And then my daughter.
Michael talks to children like they are adults. He burdens them with adult problems.
My son tells me, oh, he took Malia in the room and locked me out. I'm like, what?
Who's Malia?
My daughter,
This is criminal.
2-year-old daughter.
Who is babysitting your
Yeah.
children without your permission or consent.
And I'm very concerned. And then my son goes and tells me that. And then my daughter, my sister, I bring my brother's house, and my sister-in-law asks Malia, hey, is Joe touching you? She's like, yeah, where? And she points at her vagina. I'm like, oh man, I'm livid, you know what I mean? And
So now your wife has a boyfriend who has a sexual assault history with children, and he's babysitting your children without your permission and consent.
that's what I have to do, a welfare check record. So they go over there and I filed the motion. I told okay, and which I'm just like livid. And then I ended up getting my daughter. I tried to tell my ex, hey, I'm going to bring her to the doctor, get her looked at.
Michael loved taking his kids to the doctor. It was his way of going around the rules that the court had set.
And then when I do that, I go to pick them up at daycare. She shows up at the daycare and says, you're not taking her. I go and grab her.
Wait, who shows up at the daycare? The wife?
My ex-wife shows up when we have a TPO in place.
A
It's supposed to be
restraining order.
my weekend with the kids, and she goes and starts shoving me with my daughter in my arms, starts pushing me in the hallway, which is assault, I guess. But the daycare calls the cops, and I end up they end up taking my daughter, the daycare workers, while she's over there shoving me against the wall.
So
You're
your
not
wife
taking-
starts shoving you in public. The
at the
daycare calls the
and
police.
with witnesses there, yeah. And I was supposed to have them every other weekend, so I ended up not getting it, and I couldn't bring them. She got rid of my appointment that I had, like the doctor's appointment with my daughter, wouldn't let me take her, and the Judge Harkess says, oh, you're telling your daughter that we're gonna. And it was unsubstantiated, and this doesn't look like it's the same guy. So we're denying you your visitation anymore, and we're going to give you supervised visits.
At this point, Michael was not mentally capable of unsupervised visits or having the kids on his own at any time.
I'm like, are you freaking kidding me? So I'm over there trying to be a dad and be concerned about my daughter, and I end up going and getting supervised visits. So around 2016. The Veterans Day thing that happened.
The fact Michael thinks that the Veterans Day incident is just a casual story that happened one time speaks volumes.
She calls me to go to pick up the kids on Veterans Day, right? Because they didn't have school. I had to go pick them up at her parents'. I show up, and that's when I saw Joseph Rue sitting there, and I said, "Joe, you touching my kids?"
Wait, who's Joseph Rue?
Her new boyfriend, and
Who was
I didn't
babysitting your kids? Where was she? Was she working?
She was actually in the house. I didn't know. I just saw her SUV and I saw him, so I thought he was dropping our kids off.
Okay.
Joe never babysat the kids. Not ever.
And I was like, "Joe, you touching the kids?" He runs inside. I didn't cuss at him. I didn't threaten him, but she put in a police report. I said I was going to kill him and stuff like that. I mean, I didn't.
Bile.
Really, I had a gun in the car if I wanted
Bile
to.
is spilling.
But anyway.
That doesn't matter.
So
Murdering your ex-wife's boyfriend while picking up the kids at the in-laws sure is funny.
anyway, he runs inside, and then I go. My parents-in-law are in the garage. I guess my kids heard it, and I didn't see my kids, so I go over there, and I get my daughter gets handed to me in her backpack. So I have my daughter in my arm. My son is in the corner. He's a little scared because he heard me yelling. And I'm like, come on, Mason, let's go. Let's
What were you yelling about?
Oh, just yelling at Joe. I was like, are you touching my daughter? This is around the same time.
Okay.
So I go see my son, or say, come on, let's go. We got to get out of here. Because they say, oh, we're going to call the cops. I'm like, I have a TPO in place. And then she comes out of the garage and starts yelling at me and say, oh, how dare you, blah, 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 or whatever. And I grab my daughter, and it won't give me my son. I try to grab my son's arm. Let's go. And her mom, like, blocks me out of the way.
The only word for that situation is horrifying. Those poor kids getting yanked around by their crazy father.
I don't touch her at all. I have my daughter on the backpack and on arm. I end up just leaving because they call the cops, and there's a TPO in place.
That's called absconding.
So I end up leaving, and
TPO is restraining order, temporary restraining order.
And then the cops call me and say, oh, did you go to her parents' house? I was like, yeah, we have an arrangement to go pick up the kids. And she told me she wasn't going to be there, and she's there. I was like, oh, well, you violated protective order because you saw her, and she said you pushed her. It's like, I never touched her whatsoever.
Incorrect. You pushed her.
And like, okay, where are you? I'm at my grandparents' house that was right down the street. That's where I originally wanted them to do it because her parents were a little hostile, you know. And then they end up going and said, "Oh, where are you?" I'm at my grandparents. "Oh, we're gonna come over there. Wait right there. We'll get your statement." I was like, "Are you gonna arrest me?" Like, "Yeah, you're gonna go to jail." I was like, "What?"
Wait, why would they arrest you?
Because they said I violated the protective order because I was there.
Incorrect.
Because I was within 100 yards of her. When she baited me to come there and said she wasn't there, and she's there. So, and it was my weekend to have the kids, you know? So I ended up taking off, and I went to my brother's house. And my sister-in-law asked my daughter, "Is he touching you?" And she said yes. Or like, "Dude, you got to get her looked at or whatever." And I'm like, "Man, I don't know what to do." You know, the cops are like coming. My brother ends up trying to bring my daughter to the hospital.
The McDonald family is a bunch of crazies. Just look at the behavior.
And I guess the ambulance comes or something, and I leave my daughter at my brother's house to go pick up some clothes for her and stuff. And the cops were looking for me at the time too, and I'm just like, "What do? I don't even know what to do. I don't want to get arrested for some stupid bull, you know." And I ended up going and CPS ended up coming and grabbing my daughter and bringing her back to my ex. And the cops were out looking for me, you know, and I ended up not staying at home that night. And
These are the actions of a very guilty man.
I just go back to work as normal, and then I go back to court. I have a court hearing in January, and I go to court for the protective order. So they charged me with violation of protective order and domestic violence because they said I pushed her, and they charged me with criminal violation of protective order for trying to call her. She actually recorded me on a phone call on her computer and said, "Oh, Mike, I'm recording you." I said, "Can I talk to the kids? I have an order saying I can talk to them on the divorce decree." And she said, "Oh, you're violating protective order," or no, she says, "I'm recording this." I said, "I do not consent to any call recordings."
When you are violating a restraining order, things are different.
So I told her that, right? And then she presented that video in court at that hearing, and I ended up going to trial on it. I asked for trial by was the girl was Alyssa Inkelstead, and the fifth one was this Gregory, Julian Gregory was a public defender, and he didn't. I gave him an email.
A public defender in family law or public defender in criminal?
Municipal court, criminal court.
Okay.
So I was getting charged with
violating a restraining order.
6 months, within 100 yards. So they're trying to charge me with almost a year and a half worth of charges. And then I go to court, and they said, "Oh, because you got these charges, you didn't stay out of trouble." So, I mean, after the hearing, the judge denied me any trial by jury. I asked for another to retain my own counsel because this attorney I sent him the emails of the talking parents, and they said, "Oh no, we're not gonna."
When Michael gets deep into the lies, you can't understand what he's saying.
I didn't put that in motion. Videos that were played shouldn't have been allowed because I said I don't consent to this call recording, which is illegal. So the state of Nevada, which I didn't know is a two-party state. So, which later on I got charged with wiretapping.
Chapter 5. People are afraid of Michael Lee McDonald.
And I ended up getting charged with the judge said, my ex goes in there, "I'm afraid for my life." Judge said, "Are you really afraid? Okay, we're going to protect you, honey. Don't worry. We got this."
1. I'm sure nobody used the word honey or we got this. 2. The court was trying to protect Candace and the kids from you.
And then the judge ends up going, because I ended up testifying on the stand too, and I ended up getting, they said the judge remanded me into custody because I had that 179 suspended and said, "Oh, since you got these new charges, you didn't stay out of trouble, we're giving you 6 months, we're imposing 6 months jail on you." So they gave me 6 months. Then they gave me 25 days for domestic violence, 52 domestic violence classes, which is usually
Michael never did any classes outside of prison.
a second offense. I never even touched her, but her parents went collaborated and said that I pushed her. I never touched her whatsoever.
Chapter 6. Realty Law and the House.
As soon as I get thrown in jail, she breaks in the house that she hadn't been in for almost 2 years that I was supposed to get. I had a refi approved on. Judge Hardcastle, who filled in for Linda Marquis, I had to show up to court in chains and handcuffs and trying to ask for bail or to get out or appeal it. And she denied any stay and ordered that my house be sold. Even though she broke in the house and wasn't supposed to be in there, went and broke in my safe. I had like $5,000, gold, silver, all this stuff.
Lies, lies, lies.
Ended up going and
What
getting
year did she break in your house?
This was in 2017.
Okay.
So I get thrown in January 2017. I lost my job at Geotab. I'm over there in jail.
So
And
2 years into this divorce, it gets messier and messier.
she wanted in the divorce.
While you're in jail, she
we were
breaks into
officially
your house
divorced.
and steals the stuff out of your
Just because
safe.
her name was on the house didn't give her permission to enter the house. So then my parents go and call the cops on her and say, hey, she's robbing them blind. And they say, oh, this is a civil matter. We can't do anything. And then 2 weeks later, she goes to family court and gets exclusive possession with Judge Hardcastle. And I got another attorney called George, my mom hired, called Procopius.
What was this, your fourth lawyer or fifth lawyer?
It's like my sixth lawyer.
Your sixth lawyer? Whoa.
So,
Oh my God, Michael. That's so impressive.
and he says, oh, Judge, she's robbing him blind. And
I like this guy.
No, she's not robbing him blind. She can take whatever she... And it's like, what are you talking about? He's in jail. He can't do anything. And gave her exclusive possession of the house, allowed her to sell the house. Supposed to be sold at market value. She undersold the house by 40. Ended up throwing away all my stuff in a dumpster. My family was allowed to get stuff for like 6 hours or something to get some of my things. And
You only got 6 hours to get your possessions out of the house.
And I was
You were
there.
in prison.
Yeah, I was in jail, and my family only got some of the stuff. They couldn't get everything. And almost all my stuff gets thrown away in a dumpster. I had about $100,000 worth of IT equipment I used to sell online and on eBay from the company too. And yeah, I get thrown, all that stuff gets thrown away. And I ended up spending 6 freaking months in jail. All these homeless people, I could tell you all kinds of crazy stories about that too.
Chapter 7, the Las Vegas Jail.
See all this.
Homeless people?
Well, I was saying how many homeless people they throw in the city of Las Vegas. They had some ordinance where they just passed where you can't sit or lay on the sidewalk. So they're going sweeping all these homeless people and incarcerating them against their will.
Just say, I don't know.
Or sleeping on the sidewalk, or going instead of telling them to move somewhere, they go throw them in jail for a couple of nights.
Okay.
And which is crazy. It's a deprivation of rights. They go and throw them in jail, and all these poor homeless people were getting thrown there. And I'm over there sitting in jail, can't do anything. My whole house gets sold illegally.
Divorce is a bitch if you choose not to cooperate.
I was supposed to be released in June of 2017. June of 2017 comes, my date comes, I'm like, I'm leaving today, finally, I'm out of here, this craziness.
Were you in jail or prison?
In jail.
In
City
jail. In
jail.
Las Vegas, city jail.
And
that was horrible.
And they just passed a thing where you trial by jury. Anyway.
So you're saying for criminal offenses or misdemeanors? For misdemeanors, you can have a jury if you want to.
No, misdemeanors, you can't have a jury.
But did they change that law?
They just changed the domestic violence here recently. Yeah.
Okay.
And I filed a mandamus to try to get that records. It's serious. It was horrid. I had to go be a porter there and
what's a porter?
What's everything?
Serve food and mop the floors and stuff like that. And I'm over there reading every book I can and just praying to God. And I hear, I almost feel God ask me, can I use you? Can I use your story? Or can I, I was like, God, why me? Why is all this happening? I keep reading Job and read the whole Bible while I was in there. And they would have some pastors come in every Thursday, and we get some really good religious materials and stuff. And I'm just praying all the time,
Chapter 8, Final Lies and Evil Plans for the Future.
Anyway.
Okay, so once again, if people want to reach out to you,
you
founded a group.
FamilyUnificationAlliance.org.
FamilyUnificationAlliance.org. This is how to get in touch with the foundation that Michael created. Please contact them with any questions you may have.
Oh, and another thing, we try to get I talked to President Trump about this too. I was backstage with him at South Point when I was running, and I asked him, hey, can you please support HJ 121, SB 48? And he's like, oh, I can't. I tried to talk to I met Joe Biden too. I shook his hand, and
Michael may have yelled something in Donald Trump's direction, but spoke to him? I think not.
I think I have it on Instagram. I tried to get him to help pass our bill out there that's in there. So with those issues, my stepdad, he was even a psychiatrist in the juvenile justice system. He worked there for many years, and would go through, see all these kids who would, try to burn their parents alive or cause different issues. And so anyway, yeah, it's a big issue. We got a lot of work to do, and we're working on it. We're raising money. We're applying for some grants.
There is no we. There are no grants. There's just Michael and his hatred.
And it's highly needed. We gotta help to be that resource to do stipulated orders, to keep it out of a crazy judge's orders that order something that's not in the best interest of the children. And if two parties can agree, which it's hard to do sometimes to mediate that, but it's highly needed. And we should also be teaching people to do whatever you can to stay together if you have children.
Jail.
Don't you want to get all these judges fired?
Even Michael knows how ridiculous that sounds.
Oh yeah, a lot of them should definitely need to be off the. And these judges need to get mental evals too. I mean, that one shooting himself that was in my case, you know, and a bunch of other these judges and attorneys, they don't have mental evals. They don't have a. They have a judicial college they go through, and then they become a judge. You know, and they have a thing called CLEs, which is continuing education and learning. They get credits for. They have to do every year. We're trying to build out and teach judges and attorneys how to deal with some of these matters as well, and stop being so despotic or unjust, or you know, it's so corrupt. You know, unchecked power.
Judges are unchecked power.
Yeah.
The interviewer might be confused about a few things regarding the judiciary.
Unchecked power. What power unchecked is? It's just
Every single time you have a trauma or drama,
okay.
you should never experience this again.
Nobody should have to experience this, and especially being alienated from their children. It's so torturous and soul ripping to lose your own flesh and blood and not be in their lives. So yeah, but hopefully we'll get these things passed soon and be able to help and change and reform these things. So
Thank you for taking alliance.com.
yeah.
May the goodness bless your life. God bless you. Peace.
Thank you.
That was
That was so bad in so many ways. This man will never stop.
And I'll just need a minute to switch this over to the document camera. Okay. All right, and I'm going to adjust the settings, Candace, and then I'll show you States Exhibit 7. So we have States Exhibit 7 on the document camera here. And Candace, what are we looking at here?
At the top is a forwarded email I forwarded Karchner's email to Mark and asked him if he would call the detective. I provided the number, and then I mentioned I'll work on getting the videos to him. By that I meant the YouTube videos of our divorce, which he didn't need. So, but I just mentioned that in that email.
And is this does this indicate the date of the email here?
Yes,
Okay.
Thursday, April 12, 2018.
Okay. And then looking on the same page further down at the bottom.
Mhm.
Okay, do we see a separate email on the bottom of this page?
Yes.
What are we looking at here?
I provided for Detective Karchner Mark DeCiro's cell phone number and his email address, as well as a link to the Google Drive that Mark sent me with the recorded phone calls on them. And then I also included at the bottom of that the links to the YouTube divorce videos.
And what is the date on this email?
April 5th, 2018.
Okay, and then on the following page, is that just the rest of that email?
Yes.
Okay, and now we're going to publish on the document camera what's been admitted as States Exhibit 3. And Candace, do you recognize on your screen what we're looking at here?
Yes, it's the decree of divorce for the divorce case.
Okay. And I'm going to go to the last page. And let's see. Okay, first, what are we looking at here where my pen is?
That's the family court judge's signature, Linda Marquise.
And what are we looking at here?
That's my attorney's signature, Russell Collins.
Okay. And do you see, what does it say here?
Decline to sign.
Okay. And can you tell me what that's indicating?
Michael refused.
Relevance? They refer to this on the phone calls.
All they need is a beer, Brandon, and
It's
I'm
in
good.
context to
There's
the
my
evidence.
standards.
And it's overruled. You can continue. Michael had declined to sign the decree of divorce, and so the judge had to sign on his behalf.
And I'm going to go to the top of page 3 on the same exhibit. And can you read that sentence where my pen is?
Sure. The parents shall provide each other with a travel itinerary and, wherever reasonably possible, telephone numbers at which the children can be reached whenever they will be away from the parents' home for 2 nights or more.
Now, Candace, the phone calls that we listened to, other than when you received them from Mark DeCiro, did you ever hear them being played on YouTube?
I did.
Okay. And were they just audio, or were there any video or pictures with them?
It was the telephone conversations with like a montage collage of pictures.
And then I don't need you to describe in detail what all of the photos were, but were they, is it fair to say they were private photos of you and your family?
Yes.
Okay. Were they photos that the defendant would have had access to due to being married to you?
Yes.
And was one of the photos a picture of you in your bra and underwear when you were pregnant?
Yes.
Now,
Yes, Revan, I just spoke to you.
Now, Candace, in October of 2016, did you have knowledge of where the defendant lived?
Yes.
Okay. And did he live here in Clark County, Las Vegas, Nevada?
He did.
And during all of the phone conversations that we heard in court, when they occurred, were you living here in Las Vegas, Clark County, Nevada?
I was, yes.
And were you physically located here in Clark County, Las Vegas, Nevada at the time of the phone conversation?
I was, yes.
And you testified that you met the defendant in 2008. During the entire time that you've known him, have you ever known for him to live outside of Clark County, Nevada?
No.
And during October of 2016, were you aware of him taking any out-of-town trips?
I was not.
And you testified that Michael was employed during this period at Geotabs.
Correct.
Can you tell us what kind of work schedule he had?
I believe he worked like a 8 to 4, 8 to 5. I think he had an hour lunch. That was based on, pick up and drop off times with the kids. Those are things that, we need to know about each other's schedules. I think sometimes he would go in earlier than that, but.
Okay. So would he work Monday through Friday?
Correct, yes, Monday through Friday.
Okay. And is that why your kids would be in daycare sometimes?
Ouch,
Because
friend.
sometimes you'd be at work and Michael would be at work during the week?
Yes, correct.
And, but, am I correct that as a teacher you were generally working during the week as well?
Yes, Monday through Friday.
Now, all of the recorded telephone conversations that we've heard in court, did you ever give the defendant permission to record any of those telephone conversations?
I did not.
At the time you had these telephone conversations with the defendant, were you aware that they were being recorded?
I was not.
At any point during these phone conversations, did the defendant ever state to you that the conversations were being recorded?
He did not.
Court's brief indulgence. I'll pass the witness.
Thank you very much. Mr. Mueller, examination when you're ready.
Ma'am, you've testified unambiguously that these conversations occurred on October of 2016, correct?
Yes.
And you've had to listen to, and we've had to listen to a couple hours of phone calls to get the details of your divorce to verify that October 16th is when these calls occurred, correct?
I'm sorry, you're
We had to
asking,
listen to all
you're
five of these
asking,
calls. All of these incidents are certain, you're certain, occurred in October 2016.
yes,
And you wouldn't lie, and you wouldn't make any material misrepresentations of fact, correct?
correct,
And you wouldn't have been dishonest with a police officer, correct?
correct.
Can you tell me why Detective Kirchner said that these calls...
Okay,
you told him-
objection, he can't impeach with someone else's statement.
Report statement from March.
Mr.
And now he's
Mr.
testifying.
Mueller, the objection is sustained. The jury should disregard the question.
All right, ma'am, you reviewed the police report during preparation. You testified when you were getting ready to testify, did you not?
And Your Honor, he's trying to impeach with the police report, which was not written by this witness. It's not her statement.
All right, I'll rephrase. You made sure...
Sustained.
When was the last time Mr. McDonald saw his children?
Objection relevance.
The divorce is
Mr.
the...
Mueller, hold on.
Okay. The divorce is the rationale for the case.
I'm going to make a ruling. The objection as to relevant is overruled for now, given what was elicited during the course of direct examination. Mr. Mueller, you may proceed with caution.
Ma'am, there was a time during divorce proceedings when Mr. McDonald only had phone privileges with the children, correct?
That's incorrect.
There was a time when, okay, was it a time when he was only primarily allowed to talk to the children over the phone?
That's incorrect.
Okay. How was he allowed to communicate with the kids?
He was allowed no communication whatsoever.
No communication?
Except for, there was a brief period of time in December of 2016 that he had supervised visitations, and that was the only contact he was allowed. No phone calls, no letters, no pictures, no gifts, all of that was ordered. I mean, there have been different, okay, so previous to August of 2016, he had no contact. When the divorce decree went into effect, he had 2 weekends, which was the 2nd and 4th weekends of October. His next visitation was to be the 2nd weekend of November. He did not, in fact, have the kids that weekend, and from that period forward, had no contact with the children since then.
All right. Did you ever record Mr. McDonald?
No,
No. Never actually recorded Mr. McDonald?
no,
You're certain of that?
yes.
All right. Ma'am, those conversations, okay, did Mr. McDonald go to California?
I'm not sure, I
Did
mean,
he ever go to California for a seminar?
I have no idea.
You have no recollection of him going to California?
Objection asked and answered.
Sustained.
Right. Let me ask you a question, ma'am. You knew Mr. DeCiro prior to this proceeding, correct? You met him,
I met him one time, I did not know him.
all right? And your roommate worked with Mr. DeCiro, correct?
Yes, she,
And is it just a coincidence that Mr. DeCiro was the one who went into your ex-husband's Google Drive?
I'm sorry?
You're aware that Mr. DeCiro actually went into your ex-husband's Google Drive,
Objection,
correct?
this is another witness's testimony. She doesn't have personal knowledge. She only knows what she's been told.
I'm going to overrule that. If she knows, she can testify to it.
That he went into his Google Drive?
Yes.
I'm not aware of that.
You weren't aware of that at all?
No.
Okay. Now, during direct examination, you testified that there was audio recordings of your son.
There was a singular audio an audio recording, yes, between Michael and our son.
All right, was that a phone call?
That particular one was not a phone call.
So there were audio recordings on the Google Drive that were not phone calls?
There were not multiple, there was a singular recording
All
that
right.
Michael made between our son and himself.
When did he make that recording?
I don't know when he made that one because I wasn't there for that one, so I'm not sure.
All right, now, why don't those conversations begin with the word hello?
I'm not sure why they don't.
All right, could those conversations have been going and then been edited at some point so that part of the conversation was no longer there?
I have no idea.
You have no idea. Now,
I didn't make the recordings, so I'm not aware of when those recordings began or when he pressed play.
all right. Now, was this one phone call or a series of phone calls?
It was a series of phone calls.
Series of phone calls, but none of the 5 calls begin with hello. You know that? Did you notice that?
I did notice that.
Did you find that odd?
No,
Do you normally begin your conversations with hello?
sometimes.
I called you right now with your cell phone, with my cell phone. Hello?
I don't mean to be rude. I usually say like, this is Candace, but
I would not say hello. I would never answer the phone. Don't call me. I'm not going to answer the phone.
I see what you're saying. Yeah, sometimes I say hello.
So you agree that all 5 of the phone calls have no opening greeting or salutation?
I would agree with that, yes.
Okay. Now, that's a pattern. Is there any reason, do you know why? You said sometimes you talk to people and you say hello.
Mm-hmm.
Now, was there early part of the conversations that had been edited out?
I don't know. I can't say because I didn't make these recordings, so.
You can't say that there have been earlier conversations. Now, you seem to have absolutely no trouble recalling the details of these conversations for the state when you were asked, but you don't recall if the conversations were longer and there was parts of them that had been left out.
Objection asked and answered.
All right, well, I guess
That's
my,
sustained.
All right,
and
let me-
to the statement of her testimony.
all right, let me rephrase it, ma'am. One of the conversations had a mechanical voice in the background,
Yes.
all right? Now, what was that mechanical voice?
That was my gate pad, my gate code that I was typing in when I was driving.
Okay?
My phone.
Now,
All women
you
are
might go down,
microphone.
you don't have no recollection of Mike going to California for Sunrise.
Objection asked and answered.
Sustained.
Okay. Now, you use some colorful language in those audio tapes. You use the phrase, "I will come after you." Okay, what did you mean by the phrase, "I will come after you"?
For child support, that's what I was meaning. I
Okay.
would file with the district attorney for child support.
You would agree in your audio recording that you made it very clear that if you didn't get your way with financial demands, that Mr. McDonald was going to go to jail, correct?
That is the process. So yes, I was making that clear that if he continued to not pay child support, then they would revoke his driver's license first, and then after the revocation of the license is then jail time.
All right, now, did you actually meet with the detective? Yeah, let's. Did you actually meet?
Detective Kartner, did
Yes.
Kartner in person?
Yes.
No, I didn't.
No.
Mueller, I don't want to have to tell you this again. I'm going to tell you one time, and I don't want to have to say it again. Stay away from Karen. Do not walk over there again, you nasty blah.
So if you didn't meet him in person, how did you get him information?
Initially, I made the police report at the precinct. It was then assigned to him. He asked me to drop off a thumb drive of the recordings, so I uploaded those. He was having trouble opening those, so he asked me if I would email him or forward him the email that Mark DeCiro had initially sent me with the Google Drive, which I did.
Right. And you would agree that you filed the police report with the detective after Mr. McDonald expressed his concerns about your child's rectal prolapse, correct?
I'm sorry, I don't follow.
Timing-wise, I want to make sure I understand the timing. He complained about who was being around the children, correct? And you responded by going down to the police station and filing an eyewitness statement, correct?
My response to him, I'm sorry, I'm just having trouble You're asking me if I filed this particular police report after he had made the claims about.
I'm not 100% sure. I think it's this lady. Lady, will you please stop? Stop. There you go, Raven.
The rectal prolapse.
Yes, ma'am.
Yes. Well, I mean, this was much later. I didn't file this actual police report until March 29th of 2018.
Did you review your report before testifying your statement today?
Did I review it before I came here today?
Yes, ma'am.
No, but I have reviewed it in the past.
Would refresh your recollection as to what you recorded.
Sure, I could
Coach?
see it. You may.
Counsels from their discovery? All right, having reviewed your statement that you gave to the police department without actually meeting with the detective, has it refreshed your recollection what you wrote in your report?
Yes.
All right, let's leave it back, please.
Do you mind if I keep it for reference?
Yes, I do, actually. If I could just have it, if you need it, I'll give it back to
Okay, thank you.
you. Now, in the statement, when did you write this?
March of 2018.
Okay.
That particular police report.
This police report.
Yes.
And you accused, among other things, you accused Mr. McDonald of coaching your son to say that he wanted to stay with him.
Yes.
Objection, relevance?
Sustained.
Is that the reporting? If I could, that's my type, I'll kind of go.
Okay, the mere fact that something's on a voluntary.
Ms. Miller, Mr. Rowley, could you please approach with Mr. Mueller?
Ma'am?
Continue down this path, or are you withdrawing that question, Mr. Mueller?
I'll rephrase and come at it from a different direction, Judge.
All right, so I'm going to ask the jury to disregard that question.
Ma'am, were you present when the phone calls, these 5 calls were recorded? Did you see a recording device?
I'm sorry?
Did you see a recording device?
I did not see a recording device.
Okay. Now, you're certain and quite certain that these all happened in October
Yes. Of 2016.
2016. Now, you only reported it in when? March of
March
19?
of 2018, because that's when I became aware that the recordings or the phone calls that had been recorded existed.
Who was the person who brought it to your attention?
Mark to 0.
Okay, now, did Mr. McDonald, DeCiro actually brought it to your attention?
Correct.
Okay, now, if you didn't have a relationship with Mr. DeCiro or you didn't know him, why was a man who's a complete stranger calling you up and getting involved in your divorce?
Objection, lack of personal knowledge. She's not going to know why another person did something.
Did Mr. DeCiro?
That's overruled. She knows. She can testify to it. Do you know him?
Do I know why he was getting involved in my divorce?
Yes, ma'am.
I have no idea.
No idea.
Overruled.
Now, when someone seems a complete stranger wants to get involved in what is clearly emotional and personal business, didn't that cause you some concern?
It caused me concern that Michael had sent him personal recordings. Yeah, absolutely. I don't know anybody that would record calls and then send them to essentially a stranger. So that part was concerning to me. But in terms of Mark bringing it to me, no, I was glad that he made me aware of that.
Well, let me ask you a question. Did you ask Mr. DeCiro some very basic questions like, did you change the format of these calls?
No, I did not ask.
Did you ask Mr. DeCiro if he had edited the phone calls?
No, I did not ask.
Did you ask Mr. DeCiro if he had any proof that Mr. McDonald actually made the phone calls?
Well, the proof was the phone call, so I didn't have to ask
The
him that.
proof was the phone calls?
Yes.
Stop right there for a moment.
Sure.
Now, have you got an electronic phone?
I do have an electronic phone.
And can your electronic phone call, or can your electronic phone make recordings?
I'm sure it can. I haven't
Alright.
ever tried.
So let me ask you a question. You've assumed, as the detective, that Mr. McDonald made these phone calls, or recorded these phone calls. Do you have a shred of evidence, or are you just assuming?
No, I'm not assuming. I know he made those phone calls.
You know.
I know.
because you're his ex-wife.
No, that's not why I know. I know because he
Okay.
also posted them on YouTube under Michael Lee McDonald's channel with a whole collage of pictures of me as well. So,
So you're.
and it was also his practice to record phone calls as well. So I do have personal knowledge of him recording other people as well. So I know it was him. There's no other
Okay,
person that would need to record these phone calls.
Moment outside the presence of the jury, please.
You may approach.
Oh, the prosecutor didn't look happy. She made a face there, guys.
Come in. You refuse to let Mr. McDonald see the children, correct?
Not correct.
You,
The courts refused to let Michael see the children.
Madam Clerk, may I have this one for the defense, ready for identification?
I was following the court orders.
There's no question. Statement.
Don't do it, Terry. He cheats.
Showing your statement again. This is the statement that you gave the police department, correct?
Yes, please.
Okay? And you would agree that you've written in that statement that you didn't make these acts?
Mr. Rule, hold on. That isn't in the evidence yet.
All right.
So, are you trying to refresh your recollection?
Trying to refresh your recollection, and I'll come to a point.
As to what point?
I wanted to understand the order of events here, ma'am.
All right, so why don't we ask about the order of events before we go there?
You learned that Mr. McDonald, we heard it on the audio tape, accused your fiancée of potentially being inappropriate with your daughter, correct?
You're asking if, at what point did I learn that?
Yes, ma'am. You heard the tape. So
Correct. That, he was making those accusations in October of 2016.
October of 2016.
Yes.
So you-
Well, September, October, and then forever now still.
Okay, and you wait 2 years to file a report.
Yes, I did, because I did not become aware of the recorded phone conversations until March of 2018. And when I became aware of those, that's when I proceeded to file the report.
Okay. Now, I want to go back to the telephone visitation that had Mr. McDonald's allowed to call a kid.
I mean, which time period? Because there were during the October 2016 time period, he was allowed to make phone calls, but that was at my discretion because he had been inappropriate with the kids. So at that point, yes. Before that time, no, because there was no contact. After that time, no, because there was no contact.
And did you pick up the phone when he was talking to the children and speak with Mr. McDonald?
Which time are we talking about here?
Well, you're certain that this all happened in October 16.
You're saying,
I mean, objectively, nice.
Sustained, let's make sure we're directing the time frame for her to answer the question, Mr. Mueller.
Certainly. Mr. McDonald spoke to the kids almost every weekend for a year, correct?
no.
No.
I mean, like I said, said, there were very long periods of time where he had no contact. There were other things in place that prevented him from having contact with the kids. As far as, I mean, and we're talking like no phone calls. We're talking no contact whatsoever. So, but during the October, after the trial for custody or the hearing for divorce and so on, there was a small window of time, which was about a month, where he could have contact with the kids.
Did anything of importance happen on March 8th, 2018?
I have no idea what happened on March 8th of
When
2018.
you spoke with the detective, did you tell him any or phone call had been reported between you and Michael on March 8th, 2018?
I don't remember anything from March 8th, 2018.
Right.
What are you looking at there?
The police department's report, Detective Kirchner's report.
And is that the date the report was produced?
This was the detective's statement saying that if you had been reported to him, it occurred on March 8th, 2018.
May I see that report?
Certainly.
Kelly and Michael hit like before I did today.
Where are you referring to?
The underlying part there says that at the very top.
It says the calls were recorded, some recorded calls were sent to him on 3/8/18. So if you're going to ask the question, make sure we're being accurate with what the document states.
Certainly. Okay. All right, with court's permission, I'll just read it.
This objection,
Well, I will read the question because I'm trying to understand.
Right.
Okay,
If you're going to
the-
ask the question, and it still needs to be from it still needs to be a proper question.
Certainly.
So what is the question you're trying to ask?
Did you report to the detective that Michael had recorded a phone call conversation between you two on March 8th, 2018?
Mr. Mueller, it says the calls were sent to him.
Respectfully, Judge, it says Michael recorded between the two. Okay, I understand, I'll move on.
I'm going to sustain the objection, Mr. Commissioner.
I don't have anything further, Judge.
All right, thank you very much. Redirect your donation.
Redirect what? He didn't ask anything.
nothing further now.
All right, we're going to release this witness.
Yes.
Questions here?
All right, thank you. And I want to make sure there aren't any additional questions. So I'll have the parties approach the bench. We have 2 questions from yesterday, and I see some more questions being asked of.
JF was my initial okay, so I have this group of friends who also have been divorced, my girls, and JF is what I always called my husband, jerkface, to them. So they think his name is JF because that's the only thing I would ever call him was JF for jerkface.
We have a few jury questions. I do allow them to write down questions, and after conversations with counsel, if they can be asked, so we'll ask them. So I'm going to ask you a few questions, and the director answers to the jury. Okay? So the first question is, when Mark reached out to you with a message on audio files, was that the first time he had reached out to you?
No, that's not the first time he had reached out to me.
When was the first time he reached out to you?
I would say probably 2 years prior to that, when all of the YouTube videos were being uploaded. And actually, I think it was I reached out to him first because I was the one that wanted to know, like, why he was interested in the case and like why everything was being posted. So, but I mean, other than that, other than those initial conversations, we didn't really communicate very much.
So either party have any follow-up questions based on those two questions?
No, Your Honor.
Mr. Mueller? Was it, I'm sorry, I wanted to try.
No, Your Honor.
Thank you very much. All right. The next question. Did you invite Michael, the defendant, to Malia's appointments scheduled by you?
Yeah, absolutely. He was allowed to attend any of her appointments, but he did not attend any of them.
Any follow-up questions based on those, on that question?
No, Your Honor.
No, Your Honor.
Next question. For the recordings we heard here in court, did they occur while you were ordered to use the Talking Parents application that you testified to here in open court?
Those particular, like, we were using both of them in conjunction at that time. Previous to the decree, we were ordered to only use Talking Parents because there was no contact. In that period of time when the decree was finished, there was allowed to be limited contact, but we were allowed to have phone calls. And then, you know, things like a list of things that I would give him or what have you, or something that he needed to communicate about appointments or something. That would be, usually we would go on there and communicate back and forth through Talking Parents. And then after that, after November of 2016, it went back to no contact, and there's been no contact ever since.
So I'm going to rephrase the question. In October of 2016, were all calls made using the Talking Parents application?
Oh no, it's an app where you just type. So we were allowed to have calls, and we were also allowed to communicate through the app.
Oh, okay. So I'm going to ask another question. Can you
Okay.
explain the Talking Parents application?
Sure. You can log in online or you can log in through an app, and it's just basically, you know, it's almost like an email, but the difference between that and email is that it's court monitored, so that the judge and anyone who works for the judge can monitor what's being discussed.
All right. Any follow-up questions based on those questions and my follow-up questions?
Just briefly, Candace, does the Talking Parents app, as you've used it, does it create any audio recordings?
It does not.
That's all.
Thank you. Mr. Mueller, any follow-up questions based on those questions?
No, Your Honor.
Thank you. All right. So this next question is a two-part question, if you will. And so I'm going to answer the first part, and the second part is for you. The first question is, can we see the rest of the divorce decree regarding the telephone communication with the children? The answer to that would be yes. You'll actually be able to take the divorce decree back with you to take a look at when we deliberate. So you'll have the whole divorce decree to take a look at. This next part is for you. If no contact had been ordered, and I'm going to limit this time period to October of 2016, if we need to clarify, we can. In October of 2016, if no contact had been ordered, why did you?
I'm very gentle with those.
In October 2016 was the only time we were allowed to have phone communication. So prior to that and then after that, there was no communication.
All right, so when did the no contact order lift?
I mean, it existed all the way up until that trial or that hearing for our final divorce. I believe in the phone calls, Michael mentions that it had been 75 days, so I believe that that's correct. So there was 75 days where he didn't see the kids or have any contact with me or the kids. Then the decree of divorce, the judge in the family court case did the facts and findings and conclusion of law, and then the decree of divorce was created. That took a little bit of time from August to like September. They were working on that, finalizing it, and then October was when it was done, and he was refusing to sign, but at that point, visitations would have started that second and fourth weekend of October, and then we would have also been allowed phone communication as well. Because, you know, in terms of we both had time with the kids, so we had to communicate, and it couldn't always necessarily be through that app. It might have been like, you know, the kid needed to be picked up at school, you're not necessarily checking that application, so there were times where we would have to talk to each other on the phone. And especially because of Malia's medical issues. So there were conversations about, those were what the conversations were about, because they were immediate.
Any follow-up questions based on those questions and her response?
No, no.
Mr. Mueller?
I never use that to talk with parents. Does it have a mechanical voice on it?
It does not.
Does it say this is being recorded?
It does not. It's just like email.
So to be clear, it's not an audio application, it's a written application.
Yes, that you can, I mean, the only other thing that you could do in the Talking Parents app is like upload a picture or attach a document. Those are the only other things that you could do.
Any additional questions?
No, good question.
Okay. Any additional questions from the jury based on those questions and those answers? Okay, everybody need to write it down. Everything has to be written down. That is, we keep it from the court record. Everybody, yeah. Give the parties approach the bench, please.
His amount of whispering has increased.
All right. The first question we received, this one is I'm going to answer, and the next one will be for you. There was a request to hear the audio file of Mr. McDonald's case. It's been 75 days. Just like the divorce decree, those recordings are now in evidence. You'll be able to take them back with you, and you'll have the ability to listen to them in the back and replay them if you need to. All right? So, yes, just not right now. You do have access to them. Ms. Maurice, this question is for you. Was visitation reestablished by you or by the court?
I have no control over visitation, so everything is done through the court system. So, and as far as you're asking, I'm assuming that question is reestablished at the time of the decree of divorce.
So let's break that down. So the calls we heard you testify took place in October of 2016.
Yes.
And on those calls, we heard conversations about Mr. McDonald's lack of contact with the children.
Okay, that was
So in
prior.
October of 2016, was there any court order in place regarding visitation?
Yes, so that would have been the decree of divorce that outlined that second and fourth weekends of the month, defined by Friday.
Okay.
And then it was only for that small period of time. But it was only October because as of November, the custody changed.
Okay, and without going into any details about that, I want to clarify, after October 2016, the custody status changed.
Correct.
Okay, all right, yes. Any additional questions for the witness based on that? Oh, we have more questions, but hold on.
No, Your Honor.
Okay, Mr. Mueller. Mr. Mueller?
One moment, Judge.
Sure, no problem.
Poor Candace probably had to divorce Joe and marry her lawyer because she couldn't afford the lawyer anymore.
Did Michael have joint visitation every weekend from July 15th through June 16th?
No.
Thank you.
All right, we have some more questions, so if the parties could approach, please. All right. So we have a couple of additional questions for you, Ms. Maurice. Before we do that, I'm going to, at this time, give a instruction to the jury that you are to consider the facts and the evidence relevant to the charges against Mr. McDonald in this case. We have certainly heard about the ongoing divorce proceedings, but what happened in the divorce proceedings is not what is at issue here, and so you're hearing them to put the evidence in this case into context. And with that, I'm going to go ahead and proceed with the questions that are still pending. So let's see here. First couple questions for you, Ms. Ruiz. Did you ever watch any of the YouTube videos that were in the Google Drive associated with Michael McDonald?
There were no YouTube videos in the Google Drive. The only thing that I saw were the recordings of the phone calls, and then there were other things in there. But I don't recall seeing any YouTube videos in the Google Drive that was forwarded to me.
Did you ever see any YouTube videos involving the same audio recordings that were introduced as part of the state's case in chief?
I did.
Right. In watching those YouTube video or videos, did you ever hear the term, and quote, "this is being recorded"?
There were two versions of that video. In the first video, yes. In the second video, in the first video, no. In the second video, yes.
And in watching that second video, can you please describe to the jury what you observed?
It was all of the phone calls, and then dubbed over badly was, "this call is being recorded." And then it would sound different because it was then the phone calls. And then right before the next one, there would be like a silent pause, and then, "this call is being recorded." And then the next call. And it was like, it sounded like it had been, I don't know, dubbed in there, or, I don't know, it didn't sound like the rest of the stuff. So it sounded like, I mean, I could tell you how I feel about what I heard.
I don't want you to do that. I don't want you to describe what you heard. All right, thank you. Ms. Michelin, Ms. Rama, any questions following up from those questions?
Yes, just briefly. Candace, when you watch these videos, were you watching them directly on the YouTube website?
I was.
Okay. So you didn't get these videos from Mark DeCiro?
I did. No.
And do you recall what YouTube channel they were posted on?
Yeah, under Michael Lee McDonald. So he had like his face picture, and then this particular video, and then a few others. And they were all in relation to either our divorce, or there was one of our kids too.
Nothing further.
All right, Ms. Mueller.
Ma'am, so you agree there was multiple versions of this audio file?
I don't agree that there were two different versions of the YouTube with the recorded phone calls.
And the recorded phone calls that we've heard today, or the audio files that we think are recorded phone calls, are the ones that don't have "this call is being recorded."
You're saying you don't hear in the, sorry, can you ask me again?
Very simple. You said a moment ago that you listened to a version of these phone calls that have dubbed in. You say it's dubbed in. That this call is being recorded. And you heard that.
A YouTube version of that, yes, but in the recordings.
Stop you right there, ma'am. And the recordings that we've heard here in the courtroom do not have "this call is being recorded" in them.
Correct.
You agree that none of these calls begin with "hello"?
Correct.
Was "this call is being recorded" at the front of the audio file, and was it edited out?
You're asking, well, I can tell you in those phone calls, Michael never said to me, "this call is being recorded."
Unfortunately, not what I asked you. I asked you a very simple question. Was this call being recorded at the front of the audio, and were they edited out from Mr. DeCiro?
I don't
Objection,
know.
compound question, and lack of personal knowledge.
Sustained. You can ask the question, first part of the question, Ms. Mueller. Are you withdrawing the question?
I think I made my point. I'll withdraw the question. Not a problem.
All right. Next question. Why or how did you not ask what the doctor's appointment was for before you canceled it? If you testified on this.
Honestly, like, we had so many.
The purse that I had when I first met you was just falling apart everywhere. I got a different purse now, but when I first met you, it was beat up.
Appointments that at that point I was just like, I don't know, I didn't make that appointment. So I really didn't think much about it. And again, I said earlier, if Michael wanted to take our daughter to the doctor, if he needed a second opinion, like, he should do that. You know, that was his right as her dad. I would have never purposely canceled an appointment. I just didn't know that it was happening. And when they call you to confirm, I'm like, I don't remember making an appointment. So, I mean, if they would have said, oh, this appointment was made by her dad, I would have been like, oh, okay, well, then fine, that's fine. Like, that's his right to take her if he felt that he needed more answers, so.
Any follow-up question based on that question?
Court's indulgence. Candace, so on the day when the doctor's office contacted you to confirm that appointment, were you working that day?
It was.
Okay, so would it have been difficult for you to suddenly get out of work and take Malia to the doctor?
Yes.
That's all.
Thank you. Mr. Miller, any follow-up questions based on that question?
No, Your Honor.
Thank you. All right. Next question. When was the first visitation order established, if you can remember?
I would say I filed for divorce in July of 2015, so there were temporary orders. Shortly after that, I would say maybe it took a month or two, and then there were temporary orders.
So you actually answered the next question was when did you file for divorce?
July 2015. Yeah.
Any follow-up questions based on those?
No, sir.
Who the hell is Mike?
Thank you. All right. The divorce decree is signed at the end of October. Did all communication and contact end with Mr. McDonald at the time the documents were completed?
No, there was communication up until Veterans Day of 2016, and then no communication after that.
And when you're referencing Veterans Day, are you referencing the federal holiday that takes place in the month of November?
Yes, correct. November 11th, I believe it was.
Any follow-up questions based on that question and answer?
No, Your Honor.
No, Your Honor.
Okay. Any more questions? Okay. Council could please approach. This is going to be a two-part question for you. The first one is, how do you know what dubbing is?
I don't know. I mean, I just used that term, but it just sounded like that it was badly inserted and it didn't sound. So I don't necessarily know what dubbing is, but I'm assuming like you insert something, I guess.
What do you mean it was badly inserted?
Like it was literally the same monotone voice all 5 times. And it didn't flow with the rest of the conversation. So, and then there were like, it would be like a pause before, and then it would say, this call is being recorded. And then like a pause after, and then the phone call would start. And so it just didn't sound seamless, I guess. That's what I mean by dubbing. I don't know, it just sounded like it was put in the middle of that.
Before I ask the next question, any follow-up question based on that question and answer?
No, Your Honor.
Mr. Mueller.
No, Your Honor.
Right. Next question is, did Mr. DeCiro tell you the calls were dubbed, and if so, when?
No, he did not tell me. All he said was that he was forwarded a Google Drive from Michael, and that there were recorded phone calls between him and I was like, okay, can I have those? And he said that he would forward me the link to that.
Any follow-up questions based on that question and answer?
No, Your Honor.
Mr. Wheeler?
No, Your Honor.
Okay. Any more questions? Okay. All right, thank you very much. May we release this witness?
Yes, Your Honor.
Yes, Your Honor.
Thank you. Please step down. Council approach the bench, please. All right, ladies and gentlemen, we are going to take our lunch recess. It's going to be longer than it was yesterday because we're also going to do some work during the lunch hour so we can go continue on with the trial hopefully seamlessly. So during this lunch recess, you're also to talk and converse amongst yourselves or anyone else or anyone other connected with this trial. Or be not to listen to any report of or commentary on the trial or any person connected with this trial. That any new information, including without limitation, newspapers, television, radio, or internet, or form or express any opinion on any subject connected with this trial until the case is finally submitted to you. It is now 12:51. I'm going to ask everyone to come back at it's going to be a weird time, but 2:40. That should give us enough time to take care of what we need to take care of here. And then we'll continue with the trial. We are moving along, and it appears that we potentially will be finished today. So with that, enjoy your extended lunch hour, and we'll see you at 12:40 for lunch hours.
All rise for the jury.
The board looks like a jury has left the courtroom. If you want to sit tight, I want to give you those jury instructions before you all take a recess. Oh, sure, yes, go for it.
Those classes, you start adding up.
Yeah, no problem.
That's on you.
No, that's on me.
Okay, let's see here. Mr. Mueller, Mr. Schler, I've got 2 copies for you, and Mr. Mueller. These, so the ones that are facing horizontal, those are the state's proposed. Mr. Mueller's are attached, so take a look at that. I haven't looked at them, so I don't have a clean draft for you all. But just to go through those, we might want to consider another instruction regarding the divorce proceedings, and so I'll invite you all to draft something over the lunch break or to come prepared to potentially discuss drafting something regarding that instruction, or if we think my instruction's been sufficient, we can certainly discuss that also. So,
Just before we start, Craig, can I have that voluntary statement back?
Sure.
actually, do you all want to go? I figure why don't we all take a break ourselves and get some lunch, and then we'll come back and finish. This way you can go through them, see if you have any objections to the, to the, whatever he's proposed, and whatever the state has proposed, and then we can talk about them.
Okay,
All right.
fine.
So why don't we come back? I'm sorry.
That was marked, so I need that.
Okay, it was not admitted.
Do you want a copy of it? But it was still marked, so I have to have it.
Okay.
Okay, we have one digit.
Do you want me to make you a copy?
No.
Okay.
All right, so why don't we all come back here at 1:45?
Okay.
Okay,
Great.
all right, thank you so much.
Alright, let's just look before it goes to the next video. Okay, it did.
Department 9 is now in session.
Yes, that makes sense. If I'm gonna go back and sell jury instructions, but yeah, if I'm running late, it's a 3:30 status check over federal court.
I could be wrong. I'm often wrong. But it looks like the state of Nevada versus Mike and McDonald. This is part 4. Tomorrow we will get to part 5. I think that's... See, this doesn't say part 6. So I don't know if this is something different or not. But we might finish this hearing tomorrow. Maybe.
I think practicing law is easy. Running a business is what will drive you to distraction.
All right, we're back on the record in case C18-333-684. Did the parties have a chance to review each other's jury instructions?
Yes, Your Honor.
Yes, Your Honor.
All right. I'm going to start with the state's. Mr. Miller, do you have any objection to any of the state's instructions?
No, the state looks like these are all stock instructions that we're treating by now. We usually, customer practice is to use the state's instructions unless there's something not covered.
These all seem standard to me as well. So I'm inclined to accept all of the state's instructions. I did think, though, that perhaps we should add a part or add another instruction. And so you go 7 pages into the state's proposed instructions. It's the one that says, you are here to determine the guilt or innocence of the defendant from the evidence in this case. Oh. I'm sorry, Mr. Miller. No, I didn't realize you hadn't walked out, or you were standing there putting your tie on. I apologize. Welcome back.
Thank you.
I feel like we should either add a part to that or add an instruction that directs the jury to not speculate what occurred or did not occur during the divorce proceedings that were discussed during the course of the trial, except to only consider them for what bearing they have on the evidence in this case. Does that make sense?
Sure.
Yes.
Mr. Mueller, I
Yes,
distracted. Did you hear me?
Yes, I did. Conceptually, I don't have any problem with that, Judge.
Okay. So we'll draft an instruction that says that. And I think we'll make it a separate instruction. So I'll have it follow this instruction, if that's okay with everyone.
That's fine with the state.
Okay, all right, we'll do that shortly. And then the next instruction is the stock evidence instruction regarding the evidence they're allowed to consider, which is the testimony, witnesses, exhibits, etc. I think we need to add a couple of words to the second to last paragraph, which reads, you must disregard any evidence to which an objection was sustained by the court and any evidence that was ordered stricken by the court. I think we need to add ordered stricken or to be disregarded by the court.
I like that. I think that this should be a part of the stock one. It's a good advisement regardless of the case.
Okay. All right. Any objections to adding those 3 words in, Mr. Mueller?
No.
Okay. Just want to make sure, I just gone through to make sure I didn't miss anything else that we needed to add or take out. Does either party, other than my instruction regarding divorce proceedings, request a bad act of, I guess we'll call it bad act or a bad act like instructions?
So instruction,
As an example, there was the phone call relating to Mr. McDonald's lack of child support payment. I mean, that is kind of related to the divorce proceedings that we're going to add that instruction, but I'm wondering if either party wants an instruction regarding that.
No.
I think that's covered by the instruction we just discussed about
Okay.
the purpose of the divorce proceedings.
Okay, all right, just wanted to make sure. All right, let's turn over to the defense proposed instructions. So the first instruction proposed is not unlawful to possess audio files. The state must prove that the audio files were recordings of phone calls and the recordings were made without consent in the state of Nevada. So I believe that this instruction is covered by the state's proposed instructions regarding what constitutes a wire interception. It specifically tells them, this is page 16, I know they're not numbered, but it says a person is not guilty of an unlawful interception if it didn't happen outside of Nevada. So I'm not inclined to give this instruction. I believe it's covered by the state's instructions.
That's the state's position as well.
I object, Judge. Specifically, my colleague, until I kept making the issue of it, continually called the audio files phone calls when it wasn't in evidence, and I believe he encouraged the jury to confuse the audio files with phone calls.
Well, Ruiz to testify during her testimony that they were phone calls. So ultimately, that will the jury will have to rely, or will have to consider and weigh her testimony, whether they believe her testimony, and whether or not it is an actual phone call. So I'm not going to give this instruction. The next instruction is testimony in this case was produced that one version of an audio file contained a warning that the call is being recorded. The state has not produced that version. You may infer that it would not be helpful to the state's case. This is a request for the equivalent of an exfoliation instruction. Mr. Mueller, what evidence do you have that would entitle you to an exfoliation instruction?
We have not one, but two witnesses in a 4-witness case have said that they've heard an audio tape that says that this court, these conversations are being recorded. We have not had such an audio tape produced, including apparently through the evidence of a search or efforts of a search warrant. We only have the self-serving testimony of 2 witnesses. Bill disclosed to Mr. McDonald that those witnesses did not deem it credible. The state hasn't produced this document or produced this, and that's exactly what, strictly speaking, it's Brady and it's exculpatory, and respectfully, I complained bitterly about this since the beginning of this case. But now I've got 2 people who testified that it says it's not, or this phone call being recorded, and the state hasn't produced it. So if they haven't produced it, it's because they don't have it, or they haven't, there's potentially exculpatory evidence out there that the state has not obtained.
Well, how do you address the fact that there was testimony from at least Mr. DeCiro that the recording was taken down off of YouTube?
It would be wonderful if, Mr. DeCiro certainly seemed to have lacked no ability to get these recordings off of the Google Drive when he wanted them. But now since Mr. McDonald's now been in custody going on, 9 months? 7 months now, we can't, suddenly he's lost his ability to get a hold of these recordings.
Well, if you look at the exhibits that were introduced, the Google Drive showed a hyperlink to the YouTube channel. So if an individual were to click on that hyperlink, which you could do even if you cut and pasted or type the hyperlink in, how is it the state's issue if that hyperlink is no longer active?
The answer is, Judge, the state has the burden of proving the case beyond a reasonable doubt. It is not a crime to say, hey, I'm going to record you because I don't like you and I don't trust you. And then later, a audio tape shows up that's been edited that has that word redacted. Now, if the state believes that this recording was illegal, then why don't we have the audio tape that both 2 of the 3 witnesses have said they've heard? Now,
No, that wasn't what they heard. They watched a YouTube video that had an audio part of it.
yes, the audio tapes that you've heard are lifted directly out of this YouTube video. This was the soundtrack that went with the video. At least that's my understanding of the state of the evidence. Now, the state has not produced the potential exculpatory audio. And I've complained and asked for relief on the fact that this audio tape has in fact been edited and reformatted and does not contain hello or goodbye with one of the conversations that
Well, the last one actually did say goodbye.
Yes. I'll retract that. But having said 4 of the 5, of the 10 potential greetings or goodbyes, we've got 9 of them missing. So, Your Honor, I believe that's a proper instruction of the law. They haven't produced the evidence that they say they've seen. Well, where is it? And if they can't produce it, then I think he's entitled to spoliation instruction.
So tell me how something that would be, I'm guessing that, again, demonstrating my lack of techiness, but hosted by YouTube would be in the care, custody, and control of the state of Nevada.
These documents were hosted by Google. I remember that was Mr. DeCiro's.
So that's the Google Drive, that would be
Google
hosted by
Drive.
Google, but we're talking about the YouTube videos that both testified to that had the quote-unquote dubbing of this call has been recorded.
Mr. DeCiro testified he heard it, okay, that he's, and Mr. McDonald's ex-wife both have listened to it. But when it comes time to prosecute the case, neither one of them can find it. Now, perhaps I've gotten a little cynical over the years doing a lot of criminal law, but it would appear to be a remarkably self-serving state of affairs. Now, the fact that they cannot produce this, and so that the jury themselves can determine if it's dubbed or edited, is an inference that Mr. McDonald's entitled to. He's entitled to an inference that the state hasn't produced the case and it's not helpful to their case.
Okay. All right, well, I'm looking at Bass hyphen Davis v. Davis. It's actually a case that you provided in relation to your proposed instructions, Mr. Mueller. The 2006 case from the State Supreme Court of Nevada. The citation is 122 Nevada 442. In that case, the Supreme Court discussed the district court's broad discretion to settle jury instructions to include the decision whether to be able to decline or oppose instruction. In that case, they were actually talking about a spoliation instruction. The court is to examine the relevant facts, apply the proper standard of law, and utilize a demonstratively rational process to reach a conclusion as to whether or not an instruction should be given. In listening to the evidence in this case, I'm declining to give this instruction. I do believe that there hasn't been any evidence elicited of the state destroyed or refused to produce any evidence that was in their care, custody, or control. The testimony that was introduced through Mr. DeCiro was that he could no longer access the YouTube videos after a certain period of time, and that goes to the weight, not the admissibility, and nor is there any inference that the state did anything to prohibit you from having access to that. It was a publicly hosted video on a publicly hosted website, and if that video did still exist, you yourself as the counsel for the defendant or the defendant himself could go retrieve it off of the internet. And I don't have any evidence that that was attempted or that it no longer exists. So I'm going to decline to give this instruction.
I think Your Honor, respectfully decline or disagree with the court's ruling. I believe it's an error, and respectfully your reasoning apparently produced or put on my shoulders a burden to obtain evidence.
No, it's no burden. I acknowledge you actually have no obligation to retrieve it. I'm really making that statement to make it clear that this was information that wasn't in the care, custody, or control of the state, but rather information that was publicly available. And per the testimony of Mr. DeCiro, no longer publicly available to at a certain point for review. All right, let's move on to your next proposed instruction, which is the audio files are not in evidence. If you believe audio files were edited, the audio files may not be considered in your deliberations. You cite to the same case I talk about with the spoliation instructions. I respectfully disagree that that case stands for that.
Respectfully, Judge, here's the state of the evidence.
Hold on, let me go ahead and let me talk about this. The Bass-Davis v. Davis case held that considering the potential consequences to the non-spoiling party. So first off, there's a distinction there. The court had made a determination that the party was entitled to the spoliation instruction. We conclude that NRS 47.250 subsection 3, the rebuttal presumption only applies in cases involving the willfully destroyed evidence. However, the jury, when properly instructed, is permitted to draw an adverse inference when the evidence is lost or destroyed through negligence. In this case, we have no evidence of a willful destruction, nor do we have evidence or an inference that the evidence was lost or destroyed through negligence. And so I'm declining to give this instruction, but Mr. Mueller, please lay your record.
Respectfully, Judge, we have a troubling state of evidence. We have 2 state's witnesses of the 3 and 4 witness case said that there's 2 versions.
So 3 witness case, so 2
witness, yeah. 3 witness case have said that there's 2 versions of this audio tape, one of which would completely exonerate Mr. McDonald, specifically a statement saying that this case, these phone calls are being recorded. Yet neither his ex-wife, who clearly, I don't think can reasonably be described as anything other as harboring ill will towards him, or Mr. DeCiro, who very clearly has some animus towards him, have been able to come up with the actual audio tape. They opined that the dubbing that was dubbed and poorly dubbed, but once again, these tapes have been reformatted and they have been clearly edited. Now, perhaps I've gotten a bit cynical over the years, but edited or adulterated evidence is not admissible or probative.
Okay, so I think the operative point of your argument is that there were a YouTube, or there was a YouTube video with the, as it's been testified to, and I'm putting it in air quotes, dubbed version of the statement, this call is being recorded. But there's been no evidence presented that those recordings still existed at the time that Ms. Louise made the report to the police, or that the police began to investigate this case. So I'm just not sure how you would be entitled to this instruction.
Well, respectfully, Ms. Ruiz became incensed 2 years after the fact, after she heard the first version, which apparently said that this call is being recorded. That version is not forwarded to the police. Somehow it's Mr. DeCiro's edited version that somehow makes it in the police records. Police officer very clearly did a miss amount.
What evidence is there that he edited the recording?
We have his the format has been changed. Number 1. Number 2, the audit trail. I hired an expert look at this stuff.
But the expert didn't testify.
No, he didn't testify because there's nothing there to testify to. And I called my colleague up and said, look, where's the rest of the file? It starts and stops. The rest of the file has been gone. Somebody's cut this very tightly.
Okay, but what is the evidence that Mr. DeCiro or Ms. Ruiz or anyone else, if it was in fact at all edited?
It actually has been edited. That's not me laying
So
down.
there's no evidence of that?
No, there's no
I'm
evidence.
not introducing evidence where I haven't gotten to your case in chief, and that's not lost on me. So what evidence is there to support, and what evidence will there be to support that it was edited? Edited.
Well, actually, the emails, they've already introduced the emails. It said the format, the detective actually went out of her way to introduce the email that says, I can't read this format, he reformatted it.
Well, reformatting it is different than editing it. That makes it in the playable format.
I think to a near certainty that the court could be comfortable if they've been edited. None of the conversations begin with the word hello. And there's 5 of them. Now,
Well, how could that mean edited? What if someone just turned on the recording midway through the conversation and then turned it off?
that's speculation, that's the preference of the jury judge.
Right. Okay, so I think to that end, we're agreeing that ultimately the credibility as to whether or not these were edited or not goes to the weight of the evidence and the weight of the audio files, not the admissibility. They have already been admitted. And so again, I go back to if there were original audio files that were located, that were unedited, and they would be located on Mr. McDonald's Google Drive.
You may recall when we began this trial, we objecting to the best evidence rule, and that the original document, or edits. My colleague did disagree with these on the original recordings. They're disagreeing with that. This is what was been presented and provided are edited audio files. The originals have never been produced, and to the extent that the state has them, I don't believe they have them either, but the original files are not to be found anywhere. Now, that's the problem, one of the fundamental problems with the case. The files get produced by someone who clearly has animus towards Mr. McDonald's and admitted has the expertise to edit files. He's waived this document. Now, this case is in a broader context down in family court. We've gone through this before, but respectfully, Mr. McDonald's, these are not the original files. Nobody can produce original files. The jury needs to know that, and they're entitled to use that fact.
Okay, well, the proposed instruction is actually a misstatement of fact. The first sentence says I guess you're saying the original audio files. but audio files are in evidence, and there is no proof one way or the other that those are or not actual copies of the instructions or of the audio files itself. And so giving instruction would be confusing to the jury, and telling them if you believe the audios were edited, you may not consider them as actually improper. They can certainly consider the evidence that has been introduced, and they consider whether or not they are edited to weigh that evidence against all the other evidence or the other evidence in the case. So this is a misstatement, and I'm not going to provide this instruction.
All right, Your Honor, and respectfully, if you would, so we can amend this, if you believe the audio files were edited, you may consider that in your deliberations.
State, I'll hear from you regarding that.
And Your Honor, the state's position is that that still isn't appropriate. I mean, the first sentence alone is just not an accurate statement, and I don't think the issue should be presented to the jury that the issue is whether or not they were edited. The issue is whether or not the defendant actually made the recording in the first place. Additionally, we have a potential problem because the audio files, as defense counsel is aware, they were in fact redacted. They removed references to domestic violence incidents between the defendant and Candace Ruiz. So I think that's an inaccurate statement to say, well, if they were edited, then you may consider the fact that they're edited.
I actually was not informed until now that they had been edited to remove references to domestic violence. So that certainly would be misleading. Actually,
Brent, I heard that as a whisper. All the hairs stood up.
the state of the evidence itself, and to do so would then invite the state to explain why they were edited, which would then cause a problem. So I'm not going to give that instruction either. Certainly that's fodder for argument, Mr. Mueller, that you believe that audio files were edited, but the ultimate question to the jury is whether or not there were wire interceptions, unlawful wire interceptions made in the state of Nevada, and if your client was the one that made them. I'm declining to give the instruction, the original proposed instruction and the modified proposed instruction.
And for the record, I object.
Understood, your objection is noted. All right, the next proposed instruction from the defendant is once consent to a phone recording is granted, it may not be revoked after it is completed. I decline to give this instruction. I believe that this is appropriate, but I want to hear from the state.
And Your Honor, I'm not certain this is an accurate statement of the law, and I'm not sure it really applies to the evidence in this case. I think there's been some confusion because the evidence that's been presented, we presented the audio files that are the subject of the charges. The YouTube video is only mentioned to provide context and a potential motive for why these why these phone conversations were recorded in the first place. So the YouTube videos are somewhat secondary to the actual offense in this case. So I don't think they don't actually serve as evidence that consent was ever given in this case, and I think it's going to confuse the jury because it's not really relevant.
Mike?
I think where this comes from is Detective Carson was asked by Mr. Mueller about if you revoke consent, is that still a crime? He had said something off the cuff, but I know of no case law. I've done research because I've had 3 cases involving this very charge. I've not seen any case law that stands for the legal analysis of what happens when one revokes their consent. Does that nullify the previously recorded telephone call? Does that nullify anything beyond that consent? And obviously the state of the facts are the audio files are found within Michael McDonald's Google Drive. He obviously pieced those together to make this montage smearing his soon-to-be and then ex-wife. And only in the second version of the YouTube videos there's some advising about being recorded. There's no, in way, shape, or form, implicit consent in this case. At best, there's some kind of passive consent if there was in fact a advisement of being recorded in a phone call proceedings. But there's no explicit consent anywhere.
All right, you're unaware of any case law that states that once consent is granted, it can't be revoked.
There was a case in, I believe, 2017 or 2018. It was the Daycare case, which is a restatement. It's a civil case that had to do with telemarketing, with a certified question from the U.S. District Court to the Nevada Supreme Court.
Right?
And that analyzed in much older, I think from the late 90s case of a soccer coach making confession or a recorded phone call while he was on a trip in California and the admissibility of that statement. So those are all the cases that I know to exist that revolve around this particular statute. Nobody talks about consent and revocation. It's all about jurisdiction.
But the DITEC case, the holding said, you certify the question in the negative, concluding that NRS 200.620 does not apply to recordings of telephone conversations with a person in Nevada without that person's consent when the recordings are made by a party who is located and uses recording equipment outside of Nevada.
Correct, that's the jurisdiction.
But that's jurisdictional as opposed to revoking consent or after the fact, changing their mind on consent. Okay, all right, Mr. Mueller, I hear from you.
Thank you, Your Honor. My colleagues, maybe something's obvious to me that I should spell out. If I say at the beginning of a conversation, hey, I'm going to record this because I don't trust you, or just like the judge says we're going to record this, and then later the conversation turns negative and goes for an hour long, someone takes the conversation and edits out the beginning of the conversation, now I've got an edited tape, I've got an admonishment that's been reduced, and I have an incomplete conversation. Now, I've got the same witness who says that she didn't consent to this, saying, well, when I listened to it, it said, this is called being recorded. Now, I'm deeply concerned that these recordings have been tampered with with ill motive towards Mr. McDonald. Now, here is, if she says, okay, I don't care, it's called recorded. You can't, then he starts recording it, and now she's in here in a courtroom saying, I didn't consent. Okay, so once you consent to the recording, you shouldn't hang up, but you can't, revoke the consent once a court recordation is made.
All right, so and first off, for the record, the DITEC case that I quoted from is DITEC Financial LLC versus Buckles, the Supreme Court case from 2017, and the site is 133 Nevada 498, 401 Pacific 3rd, 215. Ms. Mueller, the issue is that there is no evidence that consent was ever made or given in this case. Rather, what we have is testimony that consent was dubbed in. Considering, I'm actually going to reconsider my position. I think that it would be confusing to the jury. Now, Mr. Mueller, again, you're free to argue that there was a recording that apparently said this is a recorded call and that the jury can infer consent, but we have no evidence that consent was ever given. And if I recall correctly, Ms. Ruiz testified specifically that she did not give consent yesterday during her testimony. All right, so I'm not going to give this instruction, and your objection is noted. Anything else you want to add to the record?
No, Your Honor, there is one instruction in the states that needs to be redacted. The one that said, you are instructed the audio recording of one of the telephone conversation without consent of part of the other is unlawful interception of wire communication, and it should be comma in the state of Nevada.
Can you give me a page number, please?
No.
No, there's no page number. I'm sorry. I know which one it is, though. It's the one. Oh, did you put it? Oh, okay. It's page 15, I think.
14.
I think it's 16. I'm sorry. Is that what you're talking about?
Yes.
Well, this one addresses Nevada law. So this one says...
There's one right before it that says, 1 second.
Sure. Okay, it's page 15.
Oh, you want to add under Nevada law?
Yes.
At the end there? Any objection, Steve?
That's fine.
Yeah, no objection.
Okay.
So we need the same one.
All right.
It's more of a definition.
So my last, question or issue, if you will, is the verdict form. So we have the 5 counts listed out, but I think that the jury needs to be instructed that they need to find that there were 5 separate recordings in order to find Mr. McDonald guilty of 5 counts of this offense. So I guess I should have got track of that. I have a second proposed instruction. And the second proposed instruction should be that the jury, in making their jury deliberations, must determine if there were 5 separate phone calls. Then the verdict form should read should be a special verdict form. So as proposed, it's fine, but I think we need to add in each part in the affirmative, yes or no. Audio recording 1 was a separate recording from counts 2, 3, 4, and 5, and then go through each count. That way, they're making a determination with 1, it's a separate call, because Mr. Mueller has been arguing in the opening statements that it's one continuous call. Because if not, we're going to have an issue with just determining whether or not the jury, A, found there were 5 calls, assuming they find him guilty. If they don't find him guilty, then this issue is resolved. If they do find him guilty, we're going to have a merger issue and a confusion issue as to what the jury decided. Do you understand?
Yes, sir.
Do you have an objection to adding that?
I feel like that would probably be covered just by a jury instruction, like informing them that they need to find that, because I feel like that would cover it, because then if they're finding them guilty, and because they're presumed to follow the instructions.
So you prefer not to have a special finding form with the so yes and no?
I prefer not to add that to the verdict form, but a jury instruction is
All right,
absolutely.
I'll hear from Mr. Mueller.
If I can consider for a moment, Judge.
Sure.
What do you think?
No, we're going to need to, we have audio files that are edited or reformatted, at the minimum, and reformatted. We don't only have 5 recordings, 1 goodbye. We don't have any hellos. I think we're going to need to ask for special finding. We find that this was 5 seconds.
Not only were there no hellos in this phone call, but Michael McDonald's second lawyer actually committed suicide.
Recordings, or we find that these were one recording spliced, or multiple splices of one original or 2 original recordings.
Well, that does become a little complicated, because the way that I had envisioned this in terms of the verdict form would be count 1, unlawful interception of wire communications. Question 1, we find that this audio recording is separate from recordings 2, 3, 4, and 5. Yes or no? Assuming they find yes, then they move on to the deliberation of guilty or not guilty. I don't see how we could do a special finding of, unless we put that first, we find this to be one continuous recording. Do you see what I'm saying? That's where things get complicated.
I agree.
The only idea I have is if you potentially add like count 6, which is an option of a comprehensive for a finding of singular call that's still proven.
That was the alternative that I did have in my mind. Do you want that with the special findings, or and then we can instruct them, if you cannot make this determination, then you go to this. And you find a call was made.
Yeah, if you believe he's committed the crime, however, you find it's 1 call and not 5 calls, then you find him guilty of 6.
Okay.
That might be easier to follow. Obviously, we don't have many information that supports that, but as long as there's agreement of the parties, this is what the defense wants, then it's fine.
Right, it wouldn't really be a count, it would be or, and then just a generic, we find the defendant committed a violation of unlawful interception of wire communications.
Right.
Do you see what I'm saying?
I think I'm trying to work this thing through as a chess game. I think we are courting error and waste a new trial if we come up with anything other than a verdict that reflects the state's charges. I'm thinking this through. I would like to have some, catch-all verdict, but the reality is we do that, we're not answering the state's charges. The state's charged by specific theories of liability. They have to make a finding on each one.
All right, so okay. I don't think we're inviting arrow in, but I understand your concern. The alternative to that would be we find it separate. If they find no, we don't want this to be a separate call, then we instruct them that they have to find the defendant guilty of that, not guilty of that count.
Yes.
Whereas if they could still find them guilty of count 1, then it would be 1 count as opposed to 5.
That would.
Why don't I work on that,
Yeah.
and then you guys can take a look at it.
Okay.
Okay? I'll work on the other page. Okay, all right. So, I know. I'll work on don't worry about this.
Hello? This is abso-freaking-lutely being recorded. Everything you say is being recorded. I don't know if this is a 7 consent state or 2 or 1 or whatever, but I said hello and I told you this is being recorded. So when we go to court later, when I'm getting sued probably for slandering one of you, I don't know, because when I say words, bad things happen sometimes. Alright guys, we made it to the end of today's stream. Tomorrow we should finish, because they're giving jury instructions. So tomorrow we should finish this, and then there's, I don't know, another case right after it, it looks like. It looks like it's shorter though. And then there's John, the brother. It's only 4 minutes long. John, 1 minute long. I might skip all these. John, 3 minutes long. Yep, I'm going to skip all those, unless you want me to play them. And then there's one more 15-minute clip. Versus the warden. I might play them. I mean, they're very, very short. We're almost done. I think we have like 2 more days. Alright? We finish this and this tomorrow. Yeah. I think we have like 2 more days maybe. And we will be done with this. And then we're going back to clips for a while. I don't have another long case lined up. No. We're going back to the other judges and clips and that for a while. And Judge Fleischer, back to normal, guys. Alright, this is going to automatically pop some of you over to OJ. If you don't go over to OJ, I will see you some other time. I hope you guys have a great Wednesday. Or Thursday, depending where you are. See you guys. Thank you. Oh, goodbye. See, I said hello and goodbye. Goodbye.
Just right, even when my world turns gray. With a giggle, she lights the way. Kathy's laugh cuts through the gloom, eyes blue like a summer's bloom. Her humor dark and twisted, sharp in a way there's no